One key feature of international law since the end of the Cold War is less large multilateral treaties involving many countries and more bilateral treaties between two countries or smaller multilateral treaties involving a limited number of nations. Between 1973 and 1982, most nations in the world became parties to the United Nations Convention on the Law of the Sea, or UNCLOS. This treaty includes measures for the protection of biodiversity in the marine environment. In 1993, however, Australia, New Zealand, and Japan concluded a much smaller treaty, the Convention for the Conservation of Southern Bluefin Tuna. These three nations were all involved in fishing for southern bluefin tuna, and they had a collective interest in carefully managing the tuna stocks. In 1998, stocks were still declining, but Japan commenced what it described as scientific fishing for southern bluefin tuna. Australia and New Zealand said that this fishing was in fact commercial fishing in breach of the 1993 convention. Australia and New Zealand then commenced action in the United Nations, in the International Tribunal for the Law of the Sea, the body charged with resolving disputes under UNCLOS. Japan challenged the tribunal's jurisdiction because the much smaller 1993 convention contained a separate dispute resolution process. Japan said that Australia and New Zealand should have followed that process instead. The tribunal noted that this was not an unusual situation in international law. They said it is a commonplace of international law and state practice for more than one treaty to bear upon a particular dispute. There is no reason why a given act of a state may not violate its obligations under more than one treaty. There is frequently a parallelism of treaties, both in their substantive content and in their provisions for settlement of disputes arising thereunder. The current range of international legal obligations benefits from a process of accretion and cumulation. The tribunal tried to determine whether it had jurisdiction or not by undertaking a detailed and quite artificial process of pulling apart the language of the two treaties. They determined that in this instance, the dispute resolution process of the 1993 treaty should take precedence. What we learn from this case is that in the modern patchwork of many small overlapping treaties, it can be difficult for nations and for international bodies to work out precisely what their obligations are and precisely how they can be enforced.